Good morning, and thank you for joining the Guidehouse and Mayor Brown webinar on the Fair Credit Reporting Act. As many of you know, FCRA includes requirements for consumer reporting agencies, CRAs as they're known, users of consumer report information, for example, lenders, banks when you open deposit accounts, and purchasers of loans or installment contracts or dealer paper, and furnishers of information to CRAs, as well as marketers of credit and insurance products. The CFPB has an 80-page FCRA examination procedure that is detailed and prescriptive and addresses such items like obtaining consumer report information for purposes of making pre-screened offers, as well as reporting information. Additionally, the CDIA has issued material guidance on how to report various types of accounts. The guidance, as well as the requirements contained in the examination procedures, unfortunately, in some cases require subjective determination, and actual furnishing is not so simple. Additionally, incorrect treatment of a consumer's account results in inaccurate reporting. All of these factors, unfortunately, contribute to significant FCRA violations, and unfortunately, the regulators, as you'll hear, particularly the CFPB, are laser focused on FCRA. I can tell you that most of the supervisory matters and investigations I've worked on in the last year for loan servicers or other furnishers include material FCRA component. During this webinar, we will discuss the regulatory and legislative priorities, litigation trends, COVID issues under the CARES Act, agency guidance and industry standards, enforcement actions and trends by the regulators, including the CFPB and FTC, and provide suggestions on where financial institutions should focus their efforts in adapting their compliance programs to help to avoid, hopefully, the next enforcement action. Before I introduce our speakers and we perform our substantive presentation, let me turn it over to Beji to introduce Guidehouse.
Thank you, Steve. So Guidehouse is one of the world's largest global consulting firms, formed by the merger of PricewaterhouseCoopers' public sector advisory business, Navigant Consulting's global commercial consulting business, and Dovel Technologies. Together, we form a disruptive consultancy with over 12,000 talented experienced professionals with an understanding of government regulation, risk and compliance, and digital and business transformation. We are the only large-scale consulting firm out there that equally blends commercial and highly relevant public sector capabilities and insights. Thanks a lot, Steve. Pass it back to you.
Thank you, Beji. I've had the pleasure of working with Beji and his team on various consumer financial services related matters over the year, and I can attest that they're wonderful. And as you'll hear, they've got a particular expertise on the FCRA side. So let me introduce the speakers. First, I'm Steve Kaplan. I'm the head of Mayor Brown's Financial Services and Regulatory practice in Washington, D.C. I am joined today by two of my partners, David Tallman. David is a partner in our Houston office and advises financial service providers, including depository institutions, auto lenders, credit card issues, student lenders, sales finance companies, and payment providers. David's practice includes counseling and regulatory compliance related advice with a particular focus on FCRA, the reason that he is part of this presentation, as well as privacy and information security matters for financial and non-financial companies. We're also joined by Stephanie Robinson, also a partner at Mayor Brown in our Washington, D.C. office and a member of our Consumer Financial Services Group. Stephanie defends companies in connection with state and federal governmental audits, investigations, and enforcement proceedings before, among others, the CFPB, HUD, Department of Justice, and FTC, with a particular focus on, obviously, consumer credit regulatory matters, UDAP, and FCRA touches on many of the matters that she works on as well. For the Guidehouse team, you just heard from Beji. Beji is a partner with the banking, insurance, and capital markets practice of Guidehouse. He's a project leader and problem solver with significant experience and has led multiple FCRA projects, including policy and procedure reviews, assessment of the accuracy of the Metro 2 files submitted to CRAs, and operational assessments of the process used to create the Metro 2 file and eOSCR dispute process. Beji also has led teams responsible for development of business requirements and technical system requirements to be compliant with CDIA guidance and Metro 2 reporting. We are also joined by Alex Sawyer. Alex is a director of the banking, insurance, and capital markets practice at Guidehouse. Alex has 16 years of experience, a proven track record of leading a variety of engagements, and her experience includes, most importantly, assisting clients with the management of compliance and risk-related issues. And she most recently has led a number of regulatory change management and FCRA compliance engagement with a focus on mortgage, student loans, HELOC, installment, auto, and auto lending. So with that, I am going to turn it over to David.
Thanks, Steve. I will start by talking a little bit about what we see as the regulatory priorities with respect to the Fair Credit Reporting Act, from what we can glean from certain public statements that are out there, including testimony from Director Chopra, some CFPB reports, et cetera. So where we see the regulatory eyes heading as they advance their agenda. Steve, could you advance to the Chopra slide? So first thing I'll talk about here is Director Chopra's testimony before Congress during his confirmation hearings. He spoke about a number of different issues, including Fair Credit Reporting Act issues most prominently. His view is that, in light of the CFPB's consumer protection mission, FCRA is really an important issue because it is a consumer pain point. Consumers continue to discover serious errors in their credit reports, either with respect to payment histories on particular trade lines, or with respect to ID theft or other inaccuracies on their reports. And they may feel forced to make payments to debt collectors on bills they've already paid or never owed to begin with, including with respect to medical treatment related to COVID-19. Or they may experience harm or inability to receive credit in the future because of inaccuracies that cause the decreases in their credit score or other black marks on their credit reports that creditors will consider when they apply for credit in the future. All of this, according to Chopra, and I think others too, it takes increased importance in the context of the pandemic and COVID-19, where people have experienced extreme economic hardship, delinquencies on a number of different credit classes increased, and people have not been able to easily resume their rent and mortgage payments. There's have been an increase in auto repossessions. And in this environment, having accurate information becomes all the more important because of the volume of negative reporting, which is inevitably going to happen. One of the key focus points I think that Chopra and the CFPB have is on resolving systemic inequities and ensuring that the credit reporting system is fair and does not result in discriminatory outcomes. So there's going to be a focus on credit reporting algorithms, for example, to make sure there isn't a systemic bias in how these systems evaluate people for credit, and ensuring that there aren't disparate outcomes in terms of resolving credit reporting disputes fairly and accurately and on an even-headed basis without regard to race, ethnicity, sex, gender, other protected classes under anti-discrimination laws. Fundamentally, what Chopra's takeaway from his testimony was that he views the CFPB's mission is to carefully monitor markets and spot risks, to ensure compliance with existing laws, to educate consumers and promote competition, and fundamentally to protect Americans from fraud and other unlawful conduct, while at the same time ensuring that law-abiding businesses can compete. Steve, next slide. Next slide, Steve.
I'm trying, David. So keep going, and I'm gonna fix the technical glitch as you speak.
Okay. There's also a CFPB report on dispute trends, which I think provides some illumination on what they've been seeing in the context of consumer complaints. And two credit bureaus, and to generate this report, they looked at accounts with dispute flags at one of the major nationwide credit consumer reporting agencies, just to look at how the frequency of credit reporting issues, what sorts of accounts and trade lines are affected, and what the resolution has been. What the report found is that consumers who are disputing trade line information generally are younger and had lower credit scores than consumers who did not have disputes reported. And they were more likely to reside in census tracts that were majority Black or Hispanic. CFPB also observed different outcomes for accounts with reported disputes, depending on what type of account it was. It's noted that, for example, student loan accounts were relatively more likely to just be deleted entirely from consumers' credit records. Auto loans were more likely to be marked as closed and paid in full. They found that the industry trade lines with the largest share of dispute flags for the period that was covered from 2012 to 2019 were auto loans, student loans, general purpose credit cards, and retail cards. And the types of disputes varied across these asset classes. For example, for auto loans and student loans, the disputes tended to be more holistic in terms of disputing the validity of the entire trade line, that this account doesn't belong to me, it results from my theft. Whereas disputes with respect to credit cards and retail cards tended to be more along the lines of disputing particular transactions, disputing payment history, things like that. Another sense of where the CFPB is headed with respect to its regulatory priorities, I think, can be gleaned from a letter that the number of Democratic senators sent to the CFPB in November. They requested that the Bureau reform the credit reporting industry by improving credit reporting accuracy and updating its process with respect to dispute resolutions. In particular, they suggested a number of specific measures that they think that the CFPB should adopt as it goes forward. One is focusing in on how the CRAs resolve errors in credit reporting once they've been identified or once disputes have been alleged. There's a perceived failure by the CRAs to devote sufficient personnel and resources for dispute resolution. The CFPB has noted in its complaint trend reports that they've seen, particularly over the course of 2020 and 2021 during the pandemic, that the CRAs have been providing less information about the details of the dispute resolution process in over the CFPB complaint portal, for example, suggesting that their resources may be stretched. CFPB also has suggested creating an ombudsperson position at the CFPB specifically to facilitate the dispute resolution process and to help ensure accuracy, to be a mediator between consumers and CRAs. They suggest requiring the nationwide CRAs to use all 9 digits of a consumer's SSN instead of matching a consumer to a report based on partial SSNs or matching based on names. This is to ensure that when reports are furnished, that they relate to the consumer who actually is requesting credit or otherwise is involved in transaction. And further, that when information is reported, that it ends up on the right consumer report, and there isn't cross-pollination of negative information that just belongs to one consumer that ends up on a different consumer's report. They have suggested requiring the nationwide CRAs to perform periodic accuracy audits on information furnishers. To some extent, this does happen as part of the regular examination process, but I think they are suggesting a more specific and targeted review that will go back and look at a greater number of trade lines and of reports to verify that the information that they are reporting matches the information in the books and records of the furnisher. And so it's not just driven by complaints, but it also is sort of proactively looking at whether the information is accurate in light of what the furnisher actually knows about the consumer. They've suggested codifying provisions of the nationwide CRA settlement with states AGs that delayed reporting of medical debt for 6 months and removed reporting of debts that were paid out by insurance. And finally, they have suggested that CRAs, address the potential for algorithmic bias in credit score generation and other, judgmental scoring systems that evaluate consumers for participation in credit transactions or other sorts of transactions, and also to provide reports in Spanish and other languages to help consumers with limited English proficiency understand what the reports say and what sort of information is contained therein. Over the course of 2020 and 2021, the CFPB has also released reports about what it's been seeing in its examinations of both the CRAs and furnishers of information to CRAs. These highlight, areas where there are either potential violations of law or process failures that have resulted in inaccuracies and other issues with respect to consumer reports. So just to highlight a few of the things that the CFPB has cited in these reports, they've seen issues with respect to the prohibition against using or obtaining consumer reports without a permissible purpose. With respect to debt collection agencies, failures to establish and follow reasonable procedures to obtain the actual date of the first delinquency from their clients. This is information that a debt collector is required to report when it furnishes information to a CRA. It's very important information because it lots of the requirements that apply to the CRAs about how long certain information can appear on a report is keyed off of the date of first delinquency. So if that information is not there or is inaccurate, it can cause logistical issues with respect to the CRA's own obligations with respect to how long information needs to be on a report. A big focus on direct and indirect disputing processes, and especially with respect to furnishers failing to provide adequate information to the CRAs to enable the CRAs to assess what investigative steps are going to be necessary to resolve the consumer dispute. So I think there's going to be some focus on requiring furnishers to report more fulsome and accurate information in the dispute process, including with respect to, account history notes, providing a full account of the correspondence between the furnisher and the consumer, so that the CRA has a better picture of the background behind the dispute. In winter of 2021, in the COVID-19 prioritized assessments, delayed processing accommodations resulted in inaccuracies with respect to reporting consumers who were current as being delinquent or having their delinquency status improperly advanced despite receiving a loan modification, forbearance, or other accommodation as a result of the pandemic. They also observed insufficient furnishing policies and procedures causing the inaccurate information with respect to home pickups for return to lease vehicles, and untimely dispute investigations resulting from staffing challenges and both CRAs and furnishers being under-resourced during the pandemic. Summer 2021, lots of failures at the CRA level with respect to the accuracy with either continuing to report information from furnishers that had previously been suggested to be unreliable based on prior inaccuracies or a history of disputes, failures to place security freezes on a timely basis, or failure to place ID theft locks on consumer reports on a timely basis. On the furnisher level, once again, noting that furnishers were failing to conduct reasonable investigations of direct disputes on a timely basis, or to report their findings back to the consumer reporting agencies on a timely basis. Fall 2021, lots of focus on the loss mitigation and COVID-19 forbearance process. In particular, failing to investigate notices of error under the remittance rule, and instances of charging delinquency-related fees to borrowers in CARES Act forbearances, which is prohibited under the CARES Act. So with that, I will turn it over to Stephanie to talk about what we've seen in terms of significant litigation under FCRA in recent years.
So before we turn it over to Stephanie, let me just take care of a couple of housekeeping items that I should have mentioned at the beginning of the presentation. First, if you have questions, please use the chat function. We will address questions at the end of the presentation, possibly with a few exceptions, depending on how things go. Also, the views expressed in the presentation are those of the author and do not necessarily represent the views of Guidehouse or any of its clients, or of Mayor Brown or its clients. So with that, I'll turn it over to Stephanie. The one thing I will mention is that a lot of these things, I guess before I turn it over, are really, they're objective, right? They're pretty easy to at least you understand what the potential violation was and the risk. I think some of them are incredibly interesting and more difficult to assess the ultimate risk and how to address it. For example, the different outcomes depending on account type. Maybe we can talk later. We can think about why that was the case and what does that mean and how does the industry address that. So with that, as food for thought, I will turn it over to Stephanie to talk about enforcement.
Okay, thanks, Steve. And we'll get to government enforcement a little bit later on in the presentation, but first I want to talk about significant litigation. And there's really just one big case that we would be remiss not to talk about here, and it's not a furnishing case. It's the TransUnion versus Ramirez case. This was a major development in June of last year. It was the Supreme Court deciding on a case dealing with standing under Article 3 of the Constitution related to class action lawsuits against private defendants. So in this case, I'm not going to read off the slide. I think we'll share the deck after the presentation, but there was an individual, Sergio Ramirez. He was in the process of buying a new car back in 2011. And as part of that process, he had his credit pulled by the dealership. The dealership used TransUnion to pull credit, and they had opted into a special add-on product that TransUnion was offering. It was called the OFAC name screen alert. And this was a product that would place an alert on a credit report if the individual's first and last name matched the first and last name of an individual who was on OFAC's list of known terrorists and other serious criminals. And so Ramirez's name matched a name on the OFAC list, and TransUnion attached that alert to his credit file, saying that he was a potential match to a name on the OFAC list. And as a result of this, the dealership refused to sell him the car. So Ramirez was upset. He canceled a family vacation to try to deal with this. It turned out ultimately that Ramirez was not actually on OFAC's list, but TransUnion at the time didn't compare any data other than first name and last names. So he filed suit in 2012, and he got class action status with over 8,000 other people who similarly had OFAC alerts attached to their credit files. And their primary claim was that TransUnion violated the Fair Credit Reporting Act by failing to use reasonable procedures to ensure the accuracy of their credit files. They also had some other complaints about some disclosure defects in mailings that were sent to them by TransUnion, missing a required summary of rights, but that was kind of a secondary issue. TransUnion objected to the validity of this suit. They claimed that the class members hadn't shown harm and they lacked standing. And they also argued that nobody suffered harm because they'd only identified these individuals as potential matches to the OFAC list, which was not technically false. So a jury trial awarded the class $60 million in damages in 2016. That later got reduced to $40 million on appeal to the Ninth Circuit. And then in December of 2020, the Supreme Court granted certiorari on the question of class standing. And this was a 5-4 decision, and the court ruled that only the plaintiffs who could show concrete harm have standing to seek damages against private defendants in federal court. And they found that of the 8,000 or so class members, only around 1,800 of them actually had files that had been disseminated to third-party businesses. So those were the only people who could potentially have been harmed by the OFAC alert, potential match alert. And of them, only Ramirez had actually alleged that he was denied credit as a result of the potential match alert. So the court held that they found that only Ramirez had the right to sue for damages with regard to the other claims about disclosure defects in mailings that TransUnion sent, because none of the other plaintiffs could actually show that they'd even opened the mailings. So we mentioned this because it's a significant decision. It's a Supreme Court case, and it held that consumers have to demonstrate actual harm rather than just the mere existence of a risk of harm in order to seek damages in federal court. And so the lower courts are going to have to decide whether concrete harm occurred in each case. So a pretty big, significant matter that's, probably the only helpful thing we have to say for industry today before we move on later on to some enforcement actions. But I think now we can turn it over to Beji and Alexandra, to talk about some COVID-19 issues.
Great, thank you, Stephanie. So what I was going to do is just briefly walk everybody through the timeline of the COVID-19 related events from a CDIA and furnishing guidance perspective. So on March 19, 2020, the Consumer Data Industry Association, or CDIA, sent the initial notice reminding lenders that they can work with borrowers to address financial problems due to declared natural disasters. They specifically pointed them to FAQ 58. And so in FAQ 58, there are two options for reporting open and closed accounts. So delinquent accounts are also considered part of the open accounts. Option 1 was to report them as deferred with a special comment code of AW. And option 2 was to just report the account status that applies to the account, and then also use a special comment code AW. And then, or they sent them to FAQ 45, which basically said if you wanted to do a forbearance, you could, and here's how you report the accounts in forbearance. On March 26th, the CFPB came out and basically just let everybody know that they would take into account the staffing and resource-related challenges confronting financial institutions as they relate to supervisory activities and enforcement actions. This is really only relevant because earlier this year, they come back and they rescind that statement. So on March 27th, the CARES Act was passed, and in April 2nd, the CDIA basically came up with guidance around how to report. Would you go to the next page, Steve, if you don't mind? CARES Act basically, and the key message essentially with the CARES Act, piece was that not to suppress or suspend reporting of your entire portfolio. That was one key thing. The second thing was basically that, not to adjust accommodation payment history profile entries post the accommodation period. And Alex and I will get into a little bit of details on that. Still staying at high level, but still give you a little bit of details in terms of what that means. July of 2020, the CDIA also released post-accommodation reporting guidance to help furnishers with reporting post-CARES Act, and so essentially broken down into 3 different sections. So there's the CARES Act post-accommodation guidelines, there's the Fannie Mae and Freddie Mac post-forbearance guidelines, and then an FAQ related to how to do how to essentially report for the CARES Act. On April 1st, this is the rescission statement from the CFPB, where they basically said they rescinded their earlier statement, and now they're going to go back to their normal supervisory and regulatory and enforcement activities. And lastly, on July 15th, the CDIA basically came up with or released post-accommodation reporting examples, because I think there was a lot of questions out there in terms of how to report a borrower, specifically if somebody continued to stay delinquent in the post-accommodation period. So they provided some really good examples, and Alex will basically walk through those slides shortly. Steve, would you mind going to the next slide, please? So here we kind of briefly talk to the CARES Act reporting guidelines and kind of put that in a table. And this is pretty much summarizes the CDIA guidance. So they kind of classify accounts into 3 different buckets. So accounts that were current prior to the accommodation, account that is delinquent prior to the accommodation, and then accounts that are bought current during the accommodation. And there's multiple options in terms of how you wanted to report them. And I think the key things to think about essentially is, the payment history profile, what are you going to do with that? And then the account status code, right? And, there is an option for payment history, so for payment history profile, to be able to be reported accurately. So that's what that first line says. So report 0 for months during the accommodation period and then continue doing that. And our experience has been that option 2, which essentially is like just report the value D during the accommodation period, is the easiest option for was the easiest option for most of our clients. But if your servicing system has the flexibility to be able to handle the other, then do whichever one that worked well. And then other than that, really the key pieces is how do you report a trade line after the accommodation period? And to address that, I'm going to hand it off to Alex. He's going to walk us through a couple of examples.
Great, thanks, Beji. One key point I want to make is that post-reporting is becoming really important now. We're almost exactly two years from where we were when CARES Act came out, and as you know, the payment history profile goes back to 2 years. So we're really coming up on that point where some of these things might drop off of the payment history profile as well. So coming out of an accommodation, as Beji mentioned, borrowers fall into 2 categories typically, one that is current and one that is delinquent going into their accommodation. And scenario 1 that we have here, it would be a borrower that is current and has a forbearance for 180 days. So kind of the typical time that was allowed under CARES Act. So for this borrower, when their accommodation would end, they would have in the month in which it is ending and that you're reporting, you'd have a 0 days past due. The account status would be 11 current because they were current going into their accommodation. And then date of first delinquency, even though they've made no payments, they're not delinquent. And so you would 0 fill that. Now, in the following months, if the borrower doesn't pay, then that's when you would start to report delinquency as you normally would, and your date of first delinquency then would want to be, the post-accommodation date where that first payment was missed. So that's for a current borrower that went in and came out current. Steve, if you don't mind flipping to the next slide. So for this borrower, this would be somebody that was delinquent going into their accommodation. So in our example here, they're 50 days delinquent, which would be an account status of 71 going into their accommodation. Coming out of the accommodation, the 180-day forbearance, at that point, they would still want to be considered 71 or 30 to 59 days delinquent. You do not count the time in which they were under forbearance as going against their delinquency. And the date of first delinquency should be the date in which the request was made before the forbearance. So what originally they were being, that 71 is being counted on. Now, if the borrower doesn't become current and then they continue to be delinquent, essentially at that point, you need to then advance the delinquency, but you don't take into consideration the time in which they were under their accommodation. It's like that part doesn't count against their delinquency. So you should start to then count their delinquency and the number of days past due since the ending of their accommodation period. And so you would move on from in order of the delinquencies. So the key there is don't go back and count the forbearance against the borrower, but it really starts again. Their clock starts once their forbearance ends and they're coming out of their accommodation. With that, I'm going to turn it back over to Stephanie to talk about some of the significant enforcement actions that we've seen.
Okay, thanks. So we have seen a handful of credit reporting related enforcement actions over the last 18 months or so by both the FTC and the CFPB. And they're associated with some pretty large fines. I'll walk through a few of them here. So one is Vivint. So last year, this company is a smart home security and monitoring company, paid a $15 million penalty plus an additional $5 million to compensate injured consumers for misusing their credit reports. This matter involves some pretty serious fraud-like claims, as well as alleged violations of the Fair Credit Reporting Act, the Red Flags Rule, and the FTC Act's prohibition on unfair practices. So the FTC filed this complaint through the Department of Justice, alleging that Vivint violated FCRA by improperly obtaining credit reports to qualify potential customers for financing for their home security system products, which the company was selling primarily door to door. And because these products cost around $1,000 or more, a lot of the potential customers were interested in financing. So as part of this sale process, the sales rep would check credit. And if the potential customer didn't qualify for the loan, according to the lawsuit, some of this company's representatives, who were commission-only representatives, used a variety of illegal practices to make the sale go through. So some of the reps would actually go out and find a random person with the same or similar name in the white pages and use that consumer's credit history to qualify the prospective unqualified customer. And then in other cases, the sales reps would ask customers to give them the name of somebody they knew or a relative who they thought had better credits. And then they'd either add that person as a co-signer to the application without their permission, or they would actually pull their credit and then list that person's address as a previous address of the actual prospective customer. So obviously these practices run afoul of the Fair Credit Reporting Act's requirement that the company have a permissible purpose for receiving a credit report. And this, of course, harmed people because if the customer defaulted on the loan, then Vivint would refer the innocent third party to its debt buyer, which meant that there were people out there who had nothing at all to do with the transaction, had never even heard of the company, and suddenly they're being called by debt collectors and have blemishes on their credit report. So the FTC concluded that to be an unfair practice under the FTC Act. And the company allegedly knew of the problem and had fired some sales representatives for misconduct, but they apparently hired some of them back not long after. They also didn't have an identity theft prevention program in place, so that violated the Red Flags Rule. This is the largest monetary judgment to date for any FTC FCRA case, so pretty significant. And Rohit Chopra was still an FTC commissioner at the time that this settlement occurred. And so he filed his own separate statement here saying he believed the FTC didn't go far enough. His view was that the commission should have also alleged that the company engaged in deceptive practices by falsifying the credit applications, and that the company was turning a blind eye to obvious sales practice issues, which itself was unfair. And I think it was interesting to note that he also mentioned that he didn't think that the terms, the other settlement terms, beyond just the dollar figures, were sufficient. So the FTC required the company to engage third-party compliance consultants to do independent assessments. They also required the appointment of a chief compliance officer, but he said that's really just going to generate paperwork. It's not going to correct the underlying deficiencies. And his view was that people should have been fired, at the higher levels, senior management level, who allowed the sales practice fraud to continue. And he also referenced clawing back executive compensation. So this is kind of consistent with what we've been hearing from him recently, that he thinks you need to hit individuals at the companies more than just hitting them with a dollar fine. Another matter, this is from the CFPB, December 2020, CFPB issued a consent order against Santander. They imposed a $4.75 million civil penalty. This involved a host of allegations of FCRA violations, including furnishing errors, failing to promptly update and correct information, failing to provide the date of first delinquency correctly, and failing to establish reasonable policies and procedures for accuracy and integrity of information. So the CFPB alleged here that the company knew or should have known that it was reporting inaccurate information on millions of accounts because it had received notice from at least one CRA of the errors early on in the period. And it also had conducted its own internal audit, which revealed several errors, and they should have caught that. And one of the primary errors, which the CFPB alleged occurred over 23 million times, related to the inaccurate reporting of date of first default and date of account information. So this is something we're seeing repeatedly. They also reported a date of first default on some accounts that were not delinquent, and failed to report the status of other accounts. Another FTC case in November 2020 was Midwest Recovery. This is a debt collector that engaged in a practice called debt parking, which is placing bogus or questionable debts onto consumers' credit reports to coerce them to pay the debt. So these entities collected payday lending debts and medical debts and other debts that they allegedly were consistently unable to verify. And the FTC alleged that the company had received thousands of consumer complaints about this each month, and that the company should have known that the debts were invalid. There were multiple red flags that suggested this, because even when the defendants heard from consumers disputing the debts, they regularly concluded that 80 to 97% of the disputed debts were either inaccurate or invalid. So FTC ordered $24.3 million in monetary relief, but this company couldn't pay the fine, so they agreed to accept a very small fraction of that due to the inability to pay of the defendants. This one is also interesting because Commissioner Chopra again wrote a separate statement in which he disagreed with the settlement because he thought that the defendants should have been banned from the industry altogether. And especially since the company didn't have the ability to pay and consumers were not going to receive any relief from the settlement, he thought that the penalties should be much harsher on the defendants. He also mentioned he thought that the FTC should be collaborating with the CFPB to get access to the CFPB civil penalty fund so that consumers could potentially get relief. So again, he was fairly critical of the FTC here. And then the last couple of cases, again, are back with the CFPB. This Alder Holdings was in December 2020. CFPB partnered with the Arkansas Attorney General, reached a settlement with, this is another door-to-door seller of home security and alarm systems. And this company allegedly charged customers who had lower credit scores higher activation fees, but didn't provide the required risk-based pricing notice. And then AFNI was a debt collector. CFPB fined for a slew of FCRA violations, including, among other things, failing to report inappropriate data first delinquency. This debt collector specialized in collecting telecommunications debts, and they didn't have the data first delinquency from their creditor clients, and so they would instead select from whatever dates that the creditors did provide. So that might have included the date on which the telecommunication service was disconnected or when the debt was charged off. And they would furnish those as the data first delinquency. And not on the slide, but I'm sure a lot of you are aware, came out just yesterday, the CFPB sued TransUnion for violating a 2017 consent order. Really different facts here. This is sort of more of a deceptive advertising case than anything else, but it's a pretty big lawsuit. Relates to how they set up their subscription enrollment process online. The 2017 order, among other things, required them to use an affirmative checkbox when having customers enroll in certain products or services, so that customers clearly understood, hey, you're agreeing to enroll in a subscription service here. And CFPB has found that they didn't implement those required changes properly and decided to sue TransUnion as well as an individual defendant for refusing to implement the requirements of the 2017 consent order. So I think all this shows that CFPB is really very focused on the industry in general. I think we can expect to see a lot more of this, but I don't want to eat up all of our time here. If there's Q&A, I'm happy to pause there and see what questions people have.
Stephanie, do you think there's anything else that we can glean from the current the TU action or any of the other credit report related enforcement actions? And in particular, is there something people should take away that here's what we should expect to see in the future? So if you haven't looked at this, you should look at it, because if you don't, this might be, the CID or the supervisory matter that you end up with.
Yeah, I mean, I think looking back at this handful of actions, they pretty much run the gamut in terms of the practices at issue, the alleged violations. I think, we've seen repeatedly issues with reporting of data first delinquency, but then some of them talk about sales practice issues and some of them talk about enrollment issues. And so I think it's a whole host of different practices. But if we're looking back, I think it's interesting and important to take note of Director Chopra's statements as an FTC commissioner, because those two FTC settlements were, the largest settlements that we've seen. And I think Mr. Chopra's experiences with enforcement actions at the FTC are very likely to have a strong influence on his perspective and thinking. And I think we've seen that play out in his public statements, not just in this area, but in fair lending and other areas where we can go back to the statements he issued while a commissioner and see, oh, okay, he's following through on all this stuff because this is really ingrained in him now that this is his past experience. So among other things, he'd like to see clearly more consumer relief and harsher restrictions, as well as permanent bans from the industry, depending on the activity. And then in terms of where I think he's going to be looking, I think you heard a lot from all the other speakers today about the potential issues we're seeing through supervisory exams. Those can certainly turn into enforcement actions down the road. He's talked a lot, Director Chover's talked a lot about dispute handling, about medical debts. They just put something out about survivors of human trafficking. So I think we know that CFPB is taking a really hard look at furnishing as well as at the credit reporting agencies themselves. And of course, we also know Equifax disclosed in its annual regulatory filing that CFPB is investigating its dispute handling process. So there's not really any one thing that I think people should be focusing on, but I think it's just important to note that Director Chopra is very interested in this industry and not a fan, clearly.
Thanks, Stephanie. So Alex and Beji, we've talked a lot during this presentation about the objective requirements, and these are the types of things, these are the requirements that are imposed under both the Fair Credit Reporting Act as well as the guidance that's been implemented. We've seen enforcement actions that relate to just inaccurate reporting or inaccurate interpretation in some cases. Can you talk a little bit about not just the objective requirements, but some of the process issues and problems that people face, furnishers in particular, with respect to accurate reporting?
Let me take a stab at that, Alex, and then maybe I'll pass it off to you. So one of the big things that we're seeing, especially with the COVID-related activities, that basically borrowers called up and asked for a forbearance or asked for a COVID-related deferment, but that deferment was not granted at that time that the borrower called and asked for it. So there was, they maybe 30 days, 60 days later, the deferment was actually granted to the borrower. So basically what ended up happening in those 30, 60 days is that the borrower may have gone delinquent at that time because they could not actually afford to make the payments because of COVID. And a lot of times it was process related because the servicers were not able to adjust their systems or do what they needed to do to be able to grant that deferment. I suspect that could end up being an issue with the regulators when they actually come, if they actually come looking for that. Alex, did you have anything else you wanted to go over?
No, I mean, I agree 100%, BJ. I think that was, at the beginning of COVID, when people found out that they could get forbearances and delay some payments, servicers and lenders just didn't know what to do exactly. And ensuring that they had the right policies and the procedures and all of the right documentation in place at that time, it was kind of a scramble. And so, getting the right documentation to the borrower and all of those things, I think we'll start to see that when the CFPB comes back and is looking at lenders and how they treated borrowers during that time and how they were reporting and what the procedures and processes and communication was like with the lender. I do think that will be an item of interest for the regulators.
And Steve, I'll jump in on this one as well. I think that in terms of process issues that we've seen, particularly for furnishers when they are reporting a file in Metro 2 format to the CRAs. I mean, these are large files and often information is automatically collected from their servicing system of record. And there can be disconnects where the information ends up being inaccurate just because of a discrepancy between how the information appears in the record and how it ends up getting reported to Metro 2. And to give you an example of something that we've seen, for example, was where one consumer on an account filed for bankruptcy. Sometimes the servicing system would flag the entire account as being under bankruptcy, and both co-borrowers would end up getting reported to the CRA as having filed for bankruptcy when that wasn't actually the case. And to catch something like that, you've got to have solid procedures in place to audit the data that's getting furnished to the CRAs and make sure it ties back to what's actually appears in the system, but then also having procedures to respond nimbly to consumer complaints. So if you start seeing recurring complaints about someone saying, well, I didn't actually file for bankruptcy, you figure out why that's getting reported to the CRAs in that manner, and that it is a systems issue that is more systemic than a one-off inaccuracy.
Yeah, I think that's a fantastic point. And as you know, we so often hear from entities that systems take care of it. We don't have to worry about it. And obviously, when you dig into the systems, you find that's where the issues are. And unfortunately, when they're systems issues, they're often systemic problems, which then make it even more difficult to deal with. But I do think trending of complaints is obviously incredibly important. I have one other follow-up question for you, David. I mentioned it, earlier. One of the things that you talked about was the CFPB and the different outcomes for different that depend on account type. Were they able to identify why the CFPB? Did they suggest why? And what do people do with something like this?
They made some suggestions, although they didn't reach any hard and fast conclusions. So for example, they suggested that the fact that auto loans tended to be closed entirely might just result in the fact that auto loans tend to have shorter terms to maturity and might pay off sooner than a student loan, for example. They also suggested that the fact that dispute flags tended to be removed while the account remained open on non-credit card accounts may relate more to the nature of disputes on credit card accounts being with respect to individual transactions as opposed to the account as a whole. But then they also suggested that maybe some of it might have to do with industry practices with respect to having a policy of when there is a dispute, just deleting the trade line entirely as a precautionary measure, which might happen more frequently in some industry sectors than others. Ultimately, they said they didn't really have much visibility into these differences and highlighted it as an area that they would be looking into further.
So it seems like it's potentially troubling, right? At least it's interesting at a minimum, troubling at worst, but we really don't know what the actual explanations were. So it's very difficult to come up with some sort of different treatment or how to address the findings. Is that an appropriate, accurate way of saying it? I don't know if anyone else
I think it's a fair
want to
summary.
add on this one. Okay.
Yeah, agreed.
Okay, well, we are coming to the bottom of the hour, and we very, very much appreciate everyone's participation. And we will be sending a link to the recording, which includes the slides, I believe, next week. So with that, unless any of the speakers have any parting words that they want to share, I will thank everyone for attending, and I hope everyone has a good rest of the week. Thank you very much.
Thank you, Steve. Thanks, everyone.